Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense here on YouTube. Today we're going to talk about an interesting issue in the law called standing. I'll have more on that in just a moment. Well, the United States Supreme Court released a case in June called Transunion versus Ramirez, and it talks a lot about this constitutional doctrine called standing. The constitutional doctrine of standing arises out of Article 3 of the Constitution. Article 3 is the article of the Constitution that essentially creates the federal courts, both the Supreme Court and all the inferior federal courts. And what it says is the judiciary has the power to resolve cases and controversies. So it has been up to the courts then to define what are cases and controversies that can be redressed through the federal court system. And that's where the standing doctrine arose. So let me tell you a little bit about this Ramirez versus Transunion case. It involved over 8,000 potential class plaintiffs who had their credit reports flagged by a new software tool at Transunion. And that Transunion tool essentially looked at a government list that identified people who were basically guilty of financial, perhaps, transactions or crimes, or they were terrorists, or they were guilty of funding terrorism. And it flagged the names of people whose names were similar to those that were on this government list. So about 8,185 people were flagged, and about 1,800 of them had credit reports disseminated to banks and other organizations, and those individuals suffered harm as a result. They were denied credit, or they had to go in and explain that no, they were not the John Smith that was the terrorist. They were the John Smith who lived at 123 Main Street. In many cases, they were not physically harmed, but perhaps they were reputationally harmed. So the question came down to which of the plaintiffs, those in the 1,800 group or those in the 8,100 group, were suitable plaintiffs for a class action lawsuit. According to this case, a plaintiff must show that he suffered an injury in fact that is concrete, particularized, actual, or imminent. In other words, you have to have been hurt, or you're going to be hurt imminently. That's how you have the first thing you have to have in order to have standing. So in this particular case, the fact that there were some 6,600 people who perhaps had not been harmed because their credit report had not been disseminated to anyone, were they actually harmed? Or was that harm imminent? And in this particular case, Transunion had stopped using the tool, so the harm was no longer imminent. The second thing that a plaintiff has to show in order to have standing is this: the injury was likely caused by the defendant. Well, in this case, that was certainly true. It was definitely caused by the defendant. The third thing they have to show is this: that the injury would likely be redressed by the judicial relief. So you have to have a concrete injury caused by the defendant that the court can fix through judicial relief. Well, that certainly applied to the 1,800 people who had credit reports sent. They could be awarded some kind of damages or damages under the Fair Credit Reporting Act that would redress their injury. But the mere fact that these other people had their names listed, but they were never, their credit reports were never supplied to any bank or other third party, they did not have an injury in fact. And as a result, since they did not have an injury in fact, they did not have standing. Now, this probably seems like sort of a novel application of the standing doctrine, but it isn't. There is a long history of cases arising out of the Supreme Court where the Supreme Court has repeatedly recognized these three requirements for standing: an injury that is concrete and particularized. In other words, it can't be vague. It can't be, well, I'm likely to be hurt. It has to be, I'm going to be hurt, or I have been hurt. My reputation has been hurt. And indeed, that's what the 1800 people said. My reputation's been hurt. It can't be something that just, well, I could be hurt later on. That's not going to be an issue. And it's not going to give you standing. Recently, a person asked on Quora whether or not citizens of the United States could sue companies that ignored science on climate change. And this presents that same kind of standing issue. You have to show that a company that ignored climate science caused an actual injury. I don't think that's possible, even remotely, to show a concrete injury. But even if you could show that concrete injury, the court could not redress it. Well, certainly the court could order them to start paying attention to climate change science, but unless they ordered a concrete, specific form of relief that dealt with climate change, which I don't think they could, but assuming that they could, then you also have to take into account that Iran, Iraq, China, India, and a whole lot of other countries in the third world produce a lot more carbon than the United States. And as a result, even though a court could issue a ruling, it could probably not actually redress the injury supposedly arising from climate change. Now, I know there are a lot of people who don't believe in climate science and don't believe that there is climate change. I believe that the climate has changed. I'm just not sure that we can do anything about it in the United States that would not cripple our economy and that would not render us a third world power in the end. So I see both sides of this problem, but I don't think the proposals that have been advanced so far adequately deal with it. Even the climate accords from the Kyoto Protocols do not address the polluters from China, North Korea, Russia, other countries that simply dump thousands upon thousands of tons of carbon into the atmosphere every year and who have no requirement to reduce it to levels similar to those of the United States that the United States agreed to in those accords. So, my thought on the matter is that in that particular case, they don't have standing. And again, my point is not really to address climate science. I'm not an expert and don't purport to be. And my opinion on that is pretty much worthless because it's not a legal opinion. It's based on science and fact. And like I said, I'm not an expert. But I wanted to give you an example of how the standing doctrine would apply in the real world based on a question that was asked on Quora. So, if you have enjoyed this video, if you found this topic interesting or helpful, I would really appreciate it if you'd go over here and click on the subscribe icon and subscribe to my channel so you can be notified every time we release a video on this channel. And if you would, give me a good thumbs up, if you would, because if you give me a thumbs up, that will let YouTube know that this content is useful and helpful to other people, and we'll put that content in front of them. Thank you so much for watching. I hope you have a terrific day, and I'll catch you again here next time.